ready. For the record, I'm District Attorney Bill Keating, and I'm here in regard to the investigation of the death of Seth Bishop. Since the deaths in Alabama raised questions in the town of Braintree, this office has taken certain steps in doing so, hopefully in the spirit of transparency as well. Within hours after we were questioned by the Braintree officials as to police reports, we were able to issue the state police reports that existed in our office and shared them with the public. After Mayor Joseph Sullivan in Braintree conducted an internal audit and we received reports that had previously been deemed missing, we reviewed those reports with our staff and we shared that with the public. There are important public benefits to conducting an inquest. Once the district attorney has requested that inquest, the presiding judge has the power to call witnesses, subpoena information, and have witnesses served with out-of-state process. The district attorney, or my representative, can also attend and also examine witnesses. The purpose of the inquest is to obtain information as to whether a crime had been committed. An inquest is not a trial or a prosecution of anyone. The broader value of an inquest is to aid in the administration of justice. The report and the transcript will eventually be open for public inspection under the following circumstances, because the inquest procedure itself is not open to the public. But the information and the report of that judge, as well as with the approval of the judge, the minutes and transcripts of that inquest can be available to the public under the following circumstances. When it's deemed by the district attorney that no prosecution would follow from that, when after the district attorney had gone to the grand jury and presented its case and the grand jury had voted it down, commonly called a no bill, or when a trial of the person deemed responsible by that inquest is over with, and at that point that information can be public as well. We also want to move forward for this inquest because of conflicting witness statements. Our review of the materials indicates that we really don't have all the records in this case, all the reports, the notes, and there's physical evidence relating to the shooting itself and the surrounding events that we don't have. The police reports and the forensic evidence that we do have on hand raise questions about what actually occurred that afternoon at 46 Hollis Avenue in Braintree. I'm not going to take the place of the judge and the findings that he'll have, but clearly the fact that we had those questions, we felt it was imperative to move forward and get answers. When we approached the only eyewitness, when we approached the major material witness in the case, and they refused to talk to us, we had to go further to get answers. And the inquest process, given how broad it is, how it interjects an independent force, the judge is much more empowered than he would be, or she would be in any other case, I think is an excellent vehicle to answer these questions. And I must say, in this instance right now, even though it was 24 years ago, you have to think that the tragedies of Alabama could have been averted had some of those things been done. Would they have for sure? No one can answer that question. But certainly in terms of the handling of the case, those charges clearly, and we said that last week, could have been made, and as the information indicates, and again, I'm not sure if this is the information that's already in the public, but I believe it is. If you look at some of the booking sheets by the Braintree Police, the booking process had already started. Police officer had already started the booking process, already put down the charge of murder, already put down the charge of assault with a dangerous weapon. I don't think at that point they were aware of some of the other gun charges because they weren't aware whether or not Amy Bishop had a firearms permit or not. But, so clearly there were those charges that could have been brought forth and should have been brought forth.
But you